Our country has a history of discrimination, and affirmative action aims to mend these past mistakes. It seems straightforward, but the ambiguous definition of the phrase led to an important conflict on affirmative action in education. The 1960s was a time of social reform. For African Americans, it meant acceptance and equality, but not everyone was quite as welcoming of the change. Some people felt that affirmative action was reverse discrimination, a favoring of minorities instead of equality for all. Alan Bakke sued the University of California's affirmative action program, saying it was unconstitutional. The case went to the Supreme Court, where a compromise set the precedent for future cases. Affirmative action has been in the works since the Civil War. In the reformative years after the war, the 13th, 14th, and 15th Amendments were passed. An important part of the 14th Amendment is the Equal Protection Clause. In summary, it says that a state cannot deny equal rights to any person within it. The reformative legislation of the 1800s wasn't enough, and the continued mindset of Jim Crow laws and de jure segregation led to the civil rights movement of the 1950s and 60s. In 1961, President John F. Kennedy created the Committee on Equal Employment Opportunity, which enforces laws against workplace discrimination. Following in his footsteps, President Lyndon B. Johnson signed the Civil Rights Act of 1964. An important part of the act was Title VI, which stated that any federally funded program cannot exclude or discriminate against people based on race. In a speech at Howard University, he explained his reasoning.
Thus, it is not enough just to open the gates of opportunity. All our citizens must have the ability to walk through those gates. And this is the next and the more profound stage of the battle for civil rights.
In 1954, the Brown v. Board of Education case struck down the idea of separate but equal. Although schools could not be segregated anymore, there was still a noticeable lack of minority groups in college. Because minorities had been discriminated against for so long, their overall living standards were far below their white counterparts. Housing, income, and especially education were areas where the divide between races was evident. To try to make up for this lack of minorities, colleges began adopting affirmative action programs, which were admission policies to help improve opportunities for historically excluded minorities. UC Davis had a quota system, where a certain number of spots were set aside for minority groups in order to increase diversity. Out of UC Davis's 100 spots, 16 were allocated for ethnic minority students. Alan Bakke was a 35-year-old white man. He spent 4 years in the Marine Corps and another 6 at NASA before deciding to go into medicine. He applied twice to UC Davis, first in 1973, then in 1974. The first time, he was rejected because he applied late. The second time, it was because there were concerns about his age. Bakke decided to sue the school.
He stated that he was excluded from that school because that school had adopted a racial quota which deprived him of the opportunity for admission into the school.
The university argued that their program was constitutional, but the lower court judges disagreed, leading to an appeal by the university.
The Supreme Court of California, which is a very liberal court at the time, struck down the admissions plan because it took race into account, and they ordered that he be admitted. The university immediately sought review of the Supreme Court. The Supreme Court stayed that order that he should be admitted. They stayed that order, and they accepted the court. So the Supreme Court of the United States could hear that case because it raised a very important federal issue.
On October 12, 1977, oral arguments began for the landmark case that would determine the use of race in education. The conflict sparked many protests because the ruling would clearly define the use of race in admissions, which could undo much of the advancements from the civil rights movement. On June 28, 1978, the decision was announced. The court was split. There were 6 opinions and no majorities.
5 of the justices, including Justice Powell, ruled that that was basically an illegal quota system. So they struck down the system that was issued in Bakke. But another group of 5 justices, also including Justice Powell, ruled that race could be used as a factor in the admissions process, in a proper admissions process. But those 5 justices didn't agree on a common rationale.
Justices Brennan, Marshall, White, and Blackmun all agreed that race can be taken into account, even with quota systems. They took the stance that UC Davis's plan was constitutional. Justices Berger, Stewart, Rehnquist, and Stevens said that race cannot be used in any way, especially not quota systems. They said that UC Davis's plan was illegal. Justice Powell weaved a thread between the two conflicting sides and came to the compromise. While he did agree that race could be taken into account, he said it could only be a factor, making UC Davis's quota system illegal. He came up with a compromise, saying that as long as race was used to achieve diversity, it could be allowed as a factor, but not as a quota system. Race as a factor means that it can be an aspect of admissions, but it cannot be the only thing looked at, meaning it has to be narrowly tailored to each individual. Race would have to be considered along with grades, sports, and extracurriculars. Alan Bakke's conflict on affirmative action in education led to the compromise on how it could be used. Bakke graduated in 1982 before moving to Minnesota. There, he worked as an anesthesiologist at the Mayo Clinic until his retirement. While he became an intensely private man, the conflict he started was very public. Proponents of affirmative action argue that if people have taken race into account for so long to hurt minorities, then people should now use it to help minorities.
We discriminated on the basis of race for so long. I mean, taking race into account, race was it. If you were black, it didn't matter. And nothing else mattered. It was solely race that made you live a life that was horrendous for hundreds of years.
On the other hand, critics of affirmative action say that it discriminates against people who aren't helped by it.
I think it's a two-sided coin, and on the one hand, you're discriminating in favor of someone, which is good for that person, but you're discriminating against another on their race, which I believe is a wrong, and something that the Constitution and our civil rights statutes does prohibit or should prohibit.
After the Bakke case, many other cases have solidified the court's position. In 2003, the Grutter v. Bollinger case called into question the University of Michigan's affirmative action program, which looked at race as well as other factors in deciding admissions. It was deemed constitutional because it was for the compelling interest of diversity. That same year, the court decided in Gratz v. Bollinger that a point system was unconstitutional. The undergrad school gave 20 extra points to racial minorities, which was not narrowly tailored. These cases helped further define what was permissible. In 2016, the Fisher v. University of Texas case used Powell's decision to say that the university's admissions program was permissible. The university had a plan where the top 10% of every graduating Texas class was granted an admission, filling up about 70% of the spots. For the remaining spots, race would be a factor in deciding admissions. The court said that this was allowed because the use of race was narrowly tailored. Race is still a widely discussed topic nowadays, and Bakke's legacy still applies. In Harvard, Asian American students are filing complaints because of discrimination during admissions, which may lead to a case that redefines affirmative action. In an ongoing investigation, the Department of Justice is asking to see Harvard's acceptance rates because many highly qualified Asian American students have not gotten in, while other less qualified minority students have. Bakke's conflict forced America to decide on the extent of affirmative action. Powell's compromise set a standard for the use of race. Powell did not favor either side with this compromise. He took into consideration both viewpoints. To civil rights activists, the case seemed like a setback. To people who saw affirmative action as reverse discrimination, Powell was too lenient. It is important to note that while Bakke's conflict did limit affirmative action, it did not stop the idea. The debate on race still exists today. Is affirmative action still required? Isn't America more equal now? Bakke's conflict led the way for other conflicts that further define the use of race, but Powell set a standard to protect affirmative action while still being fair and constitutional. Alan Bakke's conflict led to one of America's biggest compromises. The Supreme Court was forced to examine the Constitution and make the decision that race can only be a factor in deciding admissions, changing education forever.
Just call on me, brother, when you need a hand. We all need somebody to melody.